What happens when you die without a will? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Minnesota and New York. Today we're going to have a quick discussion about what happens when you die without a will. Now, many times clients come to my office and they feel a little embarrassed because they say, you know what, I don't have a will yet. It's one of those things that I know that I need, I just haven't gotten around to it. Well, if that's your situation, I'm here to tell you that you're in a very large boat. The last statistic I saw said that 33.1% of Americans actually have an estate plan, which means 2/3 of Americans don't have a will. And if you're in that boat with all of them, don't be ashamed, but now is the time to get your estate plan in order. So if you have a will, what you've done is you've laid out a process for what will happen after you're gone. You'll have a process for guardianship of children, what happens to your assets, how liabilities are paid off. Maybe you've created a trust. There's a lot of options when you have a will. If you're in a state like I am of Minnesota, Minnesota has informal probate. So we can use the will to put your estate through informal probate, a much lower, less intense version of probate than you'll find in other places. And the goal, of course, of all this is we're going to make it easier on your family. They don't have to deal with the probate judge. They don't have to go through a lot of extra paperwork. A lot of times they don't have to hire an attorney. It's a simplified way of laying out your estate. But what if you don't have a will? Then what is the plan? Well, if you don't have a will, you actually have created a plan. And that plan is you're going to have the state do what the state says with your things. So that becomes your estate plan. Now the problem is, as you're going to see, we're now leaving it up to a judge to create what's going to happen. So when you die without a will, the legal term is called intestate, which means you've died without a will. And what happens then is the state has to essentially create the will for you. What that means is your family has to go to court and sort out your affairs. They have to file a petition with the court to start a case. Depending upon what state you're in, it's a probate court. You can have a variety of different names. For example, in New York, it's the surrogates court. You probably can't opt for informal probate if you're in a state like Minnesota if you don't have a will, because now the court's going to have to be too involved with making major decisions, and that's not going to be classified as informal probate. One of the things the court has to figure out is who's going to be your personal representative, the person who's going to be in charge of this whole process, the person who has to sell your assets, transfer them, take care of your liabilities. The court has to choose someone to do that. Next, the court has to determine who's entitled to your assets. So one of the things we may have to end up doing is literally drawing out a whole family tree for the court. And then the court has to take that family tree and look at the statute and figure out who is entitled to inherit. On top of that, we have to give notice to all those leaves on that family tree. Everybody who could inherit gets notice, and then they have to decide whether they're going to object to the notice or not. You can probably guess this draws the process out a lot longer and creates a lot more legal fees and expenses for your family. If you aren't married to your partner, let's say you're just living with your girlfriend or boyfriend, you created a major problem because they might not even be entitled to inherit. Let's say you have a long-lost brother who you haven't spoken to in years, but you're not married to your girlfriend. That brother may be the person who's inheriting everything in your estate, and your girlfriend may be left without anything. You don't control who gets your assets if you don't have a will. That means the court just gets to decide who is going to get your assets, and it could end up being with somebody who you wouldn't want to inherit. Again, your brother who you had a falling out with 20 years ago, you haven't spoken to him, he may be the one inheriting your estate, leaving your girlfriend or your partner or your other loved ones who are nearby who are not related to you genetically may be left without the ability to inherit your estate. And I'm going to tell you one secret, that the people who love intestate the most, guys like me, attorneys, because we're the people who make the most money. Because when this happens, your family members don't know what to do with the court system. They don't have to make filings. They have to come see an attorney to figure out what to do next. And those attorney's fees can really rack up. If we have to create that family tree and find all of your possible beneficiaries and send them all notices and work with the court, the legal fees add up and add up and add up. So from an attorney's standpoint, when you have somebody who dies without a will, we see a good source of business. I'm not discouraging you from paying for attorneys, but I am telling you there's a way you can really simplify this for your family, and that is to create a will. So there's two things you're going to do if you don't have a will and you want to get started right now. First thing you're going to do is check your beneficiary designations. You may or may not know that if you have a beneficiary designation, that asset passes directly to that person whose name is the beneficiary. Now, if you don't have anybody named, or if for some reason your beneficiary says to my estate, then you're going to have to go through the probate court to distribute that assets. But if you have your girlfriend as the beneficiary on your 401k plan, that plan can be distributed directly to her. And once we've checked our beneficiaries, the next thing you're going to do is reach out and get an estate plan. You're not going to do just a will, you're going to do all of the documents: a healthcare power of attorney, a living will, a durable power of attorney, HIPAA authorization, guardianship provisions if you have children. We want to make sure it all gets done. It sounds daunting, but it's not. But you want to make sure it's done so you don't leave this intestate problem for your family to sort out. You can do this one of two ways. You can try to do this all yourself. You can do the beneficiary part. There's no problem. Call up your 401k provider and make sure that's done correctly. But the second part of it, creating that estate plan, that's where you want to make sure you're working with an attorney. Work with financial advisors, work with your accountant to make sure you're getting it laid out correctly. If you need help and you need to get started, you can go to my website, andrewmayers.com. There's a red button that says schedule a legal strategy session. Click that and you'll be taken to my personal calendar. We can set up a quick strategy session, about 15 or 20 minutes, to discuss where you are in the process, what your goals are, and what are the best next steps for you and your estate plan.